In 2017, a change in the law meant that employment tribunal fees were quashed. Since then, it's been free for employees and ex-employees to bring employment tribunal claims against their employers or ex-employers. That means that we've seen a significant rise in the number of claims being brought. Employment tribunal proceedings, that is, an employee or ex-employee taking action against a business, can be complicated and emotional. If you're the employer, it's essential that you get objective, pragmatic and sound legal advice from the very outset. Employment law is a very fast-moving and rapidly developing area of law with changes to legislation and case law happening all the time. That can make it really difficult to know exactly where you stand in the event of a workplace dispute. The best defence to an employment tribunal claim is to make sure that your business practices and policies are legally compliant in the first place. Nelson's offers a service called M+, which helps you do just that. But if you do find yourself with a claim made against you, we can help you to resolve it in the best way possible. In general, an employee or ex-employee has to notify ACAS for the purposes of mandatory early conciliation before they can bring an employment tribunal claim. Sometimes the first an employer knows that a claim is going to be made against them is when they hear from ACAS. Once an employee or ex-employee brings a formal employment tribunal claim, the employer will have 28 days to respond to that claim, so really they need to move quite quickly. In certain circumstances, there may be other things that you need to consider. It could be that the relationship with the employee will continue after the case is over and that they'll come back to work for you. Alternatively, there could be other members of staff who know the employee, and in such cases, fighting a hardline legal battle could affect morale, productivity and ultimately profitability much more than a swift settlement might. There's also the time, energy and focus that preparing a case can take. This is time, energy and focus taken away from your business for as long as the case is active. Where possible, we urge our clients to take themselves out of the case and do what's best in the commercial interests of the company. At Nelson's, we take a pragmatic approach and give commercially minded advice. We recognise that every case and every business is different, so we always tailor our approach depending on individual circumstances. However, in every case, we aim to give the best possible advice at an early stage. We also realise that the best advice in some cases may be to settle the dispute as soon as possible. That may be more cost effective than engaging in a dispute that could drag on. If you want to defend the claim, we have a wealth of experience in preparing and defending employment tribunal cases. If you've got a dispute or a potential dispute with an employee and you're not sure where your company stands on employment law, then please get in touch and we'll find out how we can help.